Yes.
Mr. Stevens, I'm just going to ask you to look with me at the agency agreement for the Skipton Fund. Seamus, it's SKIP 5033_058. Oh, the screen's not on. Sorry, Mr. Stevens, there may be a technical issue.
Mr. Stevens, can you hear me?
Yes, I can.
We have a technical issue with one of the screens. I'm sorry, your evidence has been beset with the odd technical issue. I do apologise.
That's
But
right.
we have a problem with the screen. We'll just pause for a moment because it's important that
Yes.
We're probably back on, are we? No.
We don't normally have documents displayed on that screen, sir. We normally have Mr. Stevens displayed on that screen. Just need to check that
bear with us, and we'll start as soon as we're ready. It won't take very long, I don't think.
There we are. Looks there we are.
I think we might be.
Yes,
right.
we're back on. Thank you.
We can see this is a version of the agency agreement that incorporates later amendments. I don't think anything turns on that for present purposes. If we go to page 4 and we look at paragraphs C and D, if we look at D first of all, Skipton's been formed to provide services acting as the Department of Health's agent on the basis set out in this agreement. And then C, the Secretary of State for Health and the devolved administrations have entered into a service level agreement by which the Department of Health acts on behalf of the devolved administrations in relation to Skipton, and parties contribute their proportionate share to the funds distributed. So is this right, Mr. Stevens, that the Skipton's relationship was with the Department of Health, and then the Department of Health had its own arrangements with the devolved administrations?
Yes, that's correct.
And then if we go to page 10, if we look at the bottom of the page, paragraph 2.5, Skipton acknowledges that as a government department, DH is directly accountable to the Secretary of State for Health. Government policy is subject to amendment from time to time. Top of the next page. DH has a duty to act in accordance with the policy of the devolved administrations. And then that's Skipton, may only alert DH to operational issues and may not make proposals to amend government policy. How, in practical terms, did that provision of the agreement affect what you and your fellow directors were able to do and say?
It didn't have very much effect. It did mean that, for example, we were unable to raise or to make proposals about the natural clearer issue to the Department of Health, but it didn't stop us discussing the problems it caused. I don't really think that it's got in the way at all of our day-to-day operations.
If we'll come back to the agency agreement in a moment, but if we look at SKIP 5031_003, this is, I think, a pro forma letter from you. It's undated, but it's after the Archer Inquiry report and after the government has published its response to the Archer Inquiry report. And you say in paragraph 2, I note your disappointment with the government's response to the report of the Archer Inquiry. I'm aware this disappointment is widely shared. In my roles as a former chairman of the Macfarlane Trust and current chairman of the Eileen Trust, I share this disappointment and believe all those who were or are fellow trustees of these trusts are in accord. However, as chairman of Skipton Fund Limited, my reaction has to be neutral, and then you refer to the clause that we've just looked at, and then you respond at the bottom of the page to what had been a request to you to make representations to government about their response to the Archer inquiry, and you say that would require you to be in breach of the agreement. Top of the next page. I regret that both I and other representatives of Skipton Fund Limited are therefore unable to participate in the further campaigning that you support. So it would appear that you understood the provision in the agency agreement to prevent you even expressing views about the government's, or the adequacy of the government's response one way or another to the Archer inquiry, yet you could do that as chair of the Eileen Trust.
Yes.
Did that not, to some extent, disenfranchise Skipton Fund beneficiaries?
Only to the extent, only if they hadn't known about the provision in the agency agreement. This letter makes it quite clear that they would understand the problem, and therefore they should take the actions that I suggest there to get their points across.
Do you know why, so we can take the letter down, thank you. Do you know why the government included that provision in the agency agreement, and was there ever any discussion about whether it should be included?
No, I don't know why. I don't recall any discussion. I think we just had to accept that. The Department of Health, after all, and their lawyers drew up the agency agreement. We had, if we believed it to be inhibiting our actions anyway, or unrealistic, we could, at the time of during the drafting process, point this out. I don't recall any particular issue, but I certainly don't think that we objected to this clause preventing us from taking issue with the department over the scheme. No, we just had to accept it.
If we go back, please, Shomik, to the agency agreement, so SKIP 5033_058. And we go to page 16 and to the very bottom of page 16. You can see at the bottom it says confidential information includes, and then we go to the next page. All information relating to the claimants, that's no doubt unsurprising, as well as to the plans, intentions, affairs and or business of Skipton and the negotiations relating to this agreement. And then 9.2 provides that each party shall, subject to the overriding obligation of the Department of Health, keep all confidential information strictly confidential. So, at face value, this would appear to suggest that no director of the Skipton Fund could talk to anyone other than the Department of Health about the plans, intentions, affairs and or business of Skipton. Was that your understanding of the agreement?
I think that's a fair interpretation.
Did that inhibit the work of the Skipton Fund at all, as far as you can recall?
I don't think so, no.
When you gave evidence to the Archer inquiry, it's ARCH 605, I think, Shomik. If we go to page 7, electronic pagination, we can see bottom of the page. You refer in line 21 onwards to Skipton being an agent of the Department of Health. And then you say there are certain things I might find it difficult to talk about, certain questions I might not be at liberty to answer. Top of the next page. Freely, because wearing my Skipton hat, I'm in an agency position. And then there's reference in the discussion that you have with the chair to the confidentiality agreement. Were there issues that relevant to the functioning or funding of the Skipton Fund that you felt that you were unable to tell the Archer inquiry about?
I don't recall without proceeding further down those minutes.
I think if we go to page...
Question there about present funding, but I regard it as sufficient, or is it going to cover? I don't know what the next line says, or what my answer to that is.
Yes, I mean, you did then set out certain views about the Skipton Fund, and I just want to ask you about one matter. Page 16, please. Bottom of the page, you were, oh wait till we're there, you were asked at the very bottom of the page about the retrospective application of the Skipton Fund pre-July, August 2003 for bereaved widows. And you were asked, do you have a view about why it's not been applied retrospectively? You said, I personally have a view. Top of the next page. But I'm probably not at liberty to give my personal views. Is that an issue on which you now feel able to say what your view was or is?
It's not an issue on which I think I have a strong view now. I have a feeling that the whatever the problem was has been resolved by subsequent changes to the scheme, and of course now I have no idea what's happening now.
If sticking with the Archer evidence and some of the matters that you did feel able to give your views on, if we go to page 13, sorry, page 14 electronically. You will see towards the bottom of page 14, you were asked, line 22, how are people made aware of the fund, of the availability? And your answer was by the Department of Health and the devolved administration using such resources as they have, which is probably not really very well. What can you tell us about the steps that were taken, whether by the department or by the Skipton Fund itself, to raise the profile of the Skipton Fund and try and ensure that as many people as possible were made aware of its existence?
As far as finding people who might not have known about the fund, there's nothing we could do about it because we don't know who they are. So it was up to the department and the devolved administrations to do what they felt to be appropriate. I have no idea what they did or how they would have publicised it. Whenever the nature of the scheme was changed, which happened more than once, which meant we had to go back to people who had already been in touch with the fund, either been turned down or whose payments were now going to be increased. We had to do that. We had the records of who they were. We had to get in touch with them, which was difficult in some cases because you can't just write to somebody who some years ago had lived at an address talking about hepatitis C in case they'd moved, in case the letter got opened by somebody else. So that was difficult, but that only applied to people of whom we had already known. Involved a huge amount of work generally by Nick Fish, and sometimes he had to call in temporary help to do it. But as far as bringing it to the attention of people who might benefit from knowing about the Skipton Fund, but it had no relationship with them, there's nothing we could do about it.
Did you consider or ask the department to consider establishing links or lines of communication with hospital trusts or representative medical organisations or relevant royal colleges, for example, to try and raise the level of awareness amongst medical practitioners?
I don't think we ever suggested anything along those lines. I think we felt it was up to the department and the devolved administrations to generate such publicity as they believed to be appropriate.
If we have a look at SKIP 5057_053, please. And if we go to page 5, electronic page 5, so you'll see this is the Director's report for the year ended 31st of March 2014. So this is going on for a decade after the fund first started operating. If we look at the second half of the page, please, Shomek. The third paragraph down on screen, the directors believe that there may still be substantial numbers of potential applications in respect of people who died before the 29th of August 2003, where the estates are unaware of the existence of the scheme. In the cases of people with haemophilia who've been registrants of the MFT, MFT might be able to trace some of those estates. No such route is known whereby the estates of non-hemophiliacs, possibly the major proportion of this group of potential recipients, might be contacted. Do you know whether any steps were taken, whether by the department or anybody else, to try and work out a route of getting that information?
No, I don't.
Do you think that there should have been some kind of policy or system in place, perhaps instituted by the department, to inform newly diagnosed patients of their potential entitlement to apply to the Skipton Fund?
I think newly diagnosed people would have been told by their clinicians, by the hospitals who made the diagnosis, who were all aware of the existence of Skipton. But the estates of non-hemophiliacs who would not have been in touch with clinicians or hospitals, I have no idea.
So we can take
what could be done about contacting them.
But in relation to the newly diagnosed, your expectation as a director of the Skipton Fund was that patients in that position would be told of the existence, or should be told of the existence, by their clinician of the fund?
Yes.
You told us earlier when we were talking about the Eileen Trust of the work that Susan Daniels was able to do to, in some cases, assist with tracking down medical records. Was any assistance available from the Skipton Fund along similar lines to help applicants track down evidence or records?
No.
Was any consideration given to...
I think if there was an application made to the fund that clearly required certain documents to be found, Nick Fish would write back and say, what you need to do is get hold of such and such document, and I suggest you try the following sources. So Nick was quite helpful, but he didn't do the hunting for them.
Okay. Well, no doubt we can ask Mr. Fish about that when he gives evidence. In terms of the decision-making processes on applications within the Skipton Fund, were all applications ultimately considered by the administrator? Were some considered by directors? How did it work?
They all started off with the administrator. If he felt that there was a need for directors to be involved in making a decision, he would bring them to the attention of the director and point out what the problem was. If he felt that the application was straightforward, then he would come to a director for signing, because we would not make a payment without a director having signed it off. And that probably happened more, most of the time. That was the process that happened. And particularly as years went on and Nick's knowledge and understanding of the nature of hepatitis C infection grew, he was able to make more and more decisions by himself.
Was any training arranged for the administrator, either the first administrator, who we'll talk about in a few minutes, or Mr. Fish as his successor, to assist them in processing and understanding applications? Because they were ultimately having to make some form of sometimes medical judgment, were they not?
If they had to make if Nick had to make medical judgments, he would consult the such medical practitioners as we had available, which in the later years particularly was Professors Thomas and Tasheko. In the early years, medical opinions were necessary. I can't remember who we would go to then, because we didn't have any clinicians on the board then. I think he would go back to maybe to Mark Winter or somebody who knew us.
Had there been any specific training arranged for
No.
either?
No. I mean, Nick started off as the assistant administrator to the Brook. So he had seen what the process was, and he saw what had to be done when he took over the main job.
Can I ask you to look at a passage in your witness statement? It's WITN 307303. And if we go to page 41, we look at paragraph 196 towards the top of the page. You say evidence was meant to be clear-cut. Both stage 1 and stage 2 application forms were designed to place the burden of proof on the applicant's clinician, some of whom did not appreciate this addition to their workload. Now, just dealing first of all with the first sentence of that paragraph, when you say evidence was meant to be clear-cut, what do you mean by that?
Well, this goes back to something we talked about earlier, where my memory of the way we were supposed to operate was incorrect. And when I subsequently, after I prepared my written statement, saw some of the written evidence, that it would have been helpful to have seen that before. Balanced probabilities, which I had forgotten about, was embedded in everything we did. So evidence was meant to be clear-cut. It wasn't meant to be clear. I think one could say it was hoped that evidence would be clear-cut, but we could take balance of probabilities into account.
And I think balance of probabilities was itself a phrase derived from the agency agreement.
Yes, 3 years after we started operating. Yeah.
The second part of this paragraph refers to the expectation of the applicant's clinician, and you said there some of whom did not appreciate this addition to their workload. It might sound from that some potential applicants, or some applicants, were disadvantaged through not having a helpful clinician. Were any steps taken to try and address that, whether with the department or otherwise?
I don't think they were particularly disadvantaged. I think that probably some people's applications took rather longer to process by their clinician than might have been the case if the clinician had been less grudging of his time. This process of applications was all designed in the plenary meetings. Placing the burden of provision of evidence on the clinician's shoulders was something that was designed into the application process by people who were themselves clinicians. So they should have known what it was, how it would be received by hard-working doctors in hospitals being badgered by their patients.
Can we look at INQY 40244? Now this is just a note of some analysis by the inquiry of Skipton files. Can we go to the second page, please, Chamber? Can look at the bottom of the page. You'll see in paragraph 2.4, bottom of the page, that in terms of the files received by the inquiry from Russell Cook, not all applicant files still exist and most files are incomplete. Are you able to assist with what the systems were for keeping applicant files or ensuring that the files were complete?
No, the information that was passed across to BSA was, as much as it was helpful, but it was not confidential. So, I don't know what was passed across and what was retained. And Russell Cook, our administering the Skipton Fund, simply somebody has to look after the files. So they're doing. But they weren't involved in the Skipton Fund's operations at all, nor did we expect them to have any detailed knowledge of the material.
So in terms of the state of the files, is that something that Mr. Fish might be expected to have a better understanding of what the practices were?
Sorry,
so the state of the files, before the Skipton Fund ceased to operate, how files were kept, what was expected to be found and located by way of documents within a file, are those matters which Mr. Fish would be expected to have some knowledge of?
He might have, because he was the person who knew what the files contained before. I'm not sure that he made the decision on what information should be passed to BSA. He might have been involved in that process. The chief executive, Jan Barlow, was heavily involved. I don't think the directors of fund were asked at all to assist in the provision of in the transfer of information. I certainly wasn't.
If we go on to page 4 of this document. Oh, no, next page, sorry. So you'll see here, this is the inquirer's analysis of the 314 files of cases where applications were declined by the Skipton Fund and there was no appeal. And you'll see there some of the reasons that appear for the refusal of the application. If we look at the third, you'll see medical records destroyed / unavailable. Quite a significant number of refusals there, 76. And then if we go towards the bottom of the page, you can see, I think, 3 lines up from the total. There's an entry for application form, e.g. the applicant's physician's not completed the form properly or has failed to provide enough detail, and there are 10 such files. Just dealing with that latter category, if the applicant's physician had not completed the form properly or not provided enough detail, why would that be a basis for refusing the application as opposed to going back to the clinician and asking for more information?
I suspect Nick will already have gone back to the physician and pointed out the deficiencies and failed to obtain any answers. I don't think we wouldn't just throw an application form on the floor because it was incomplete. We would take steps to try and make sure that it was properly completed. But if the physician involved couldn't do it or didn't want to do it, there's nothing we can do. We can do. We can't invent information.
If we go back up to slightly higher up the table, just then returning to the category of cases where the applications were declined because medical records were destroyed or unavailable, and we see 76 cases falling within that category. Was there any policy or generally agreed approach as to how to deal with cases where, through no fault of the applicant, their medical records had been destroyed or could not be located?
All we could do was to go back to the applicant and point out the problem and leave it to the applicant to try and find a way around it, making such suggestions as we knew from our experience where the records might be found. But it wasn't up to us, I'm afraid, to do the chasing. It was up to the applicants to, and the fact that the applicants in these cases didn't make appeals might be relevant.
If we go to ARCH 302318. This is your written evidence to the Archer inquiry. Well, it's jointly from you and Mr. Harvey in relation to the Skipton Fund. And if we go to the 3rd page, please, Shomik. We can see the bottom of the page refers to cases where there are no medical records which confirm the applicant was treated with blood or blood products. It says the directors of SFL exercise, top of the next page, discretion where appropriate, and then some examples are given of where the records do show something that would demonstrate the transfusion would definitely have been needed. Then at 8.3 you say this: if there are no records available and the treatment with blood products is simply in the applicant's memory, then the application must be declined and referred to the appeal panel if the applicant so wishes. Why was that approach taken? Why, if an applicant was able to give a clear account of having received blood products or blood, but their records have been destroyed through no fault of their own, why was their account not potentially at least sufficient to allow the application?
We had applications from people who had a needle stuck in their arm and thought they were being given blood. They were actually being given saline solution or anything else that might be put into them. So the applicant's memory was not always to be relied upon.
But if you had what seemed a perfectly coherent account of receipt of a blood transfusion post giving birth, for example, or in consequence of a road traffic accident or an attack or something of that kind. This would tend to suggest that unless there's some other record which at least corroborates the applicant's account, the application would, as a matter of automatic outcome, be refused.
If there are no records of that there was a blood transfusion, and the applicant is working entirely from memory, the application would be declined, but wouldn't just be told, the applicant wouldn't be told, sorry, declined, go away. He would be given advice about how to appeal to the appeal panel, what further information, if any, might be acceptable to the appeal panel, and there would certainly be adequate encouragement to go to appeal.
That's imposing an additional burden, isn't it, though, on an applicant who may already be themselves very unwell?
True. That's the way the system was set up by other people, including ourselves. We developed this process. We went through the plenary meetings. People said, yes, that is the way to go.
Just so that I understand, are you saying that what we see set out in paragraph 8.3 of this document was how the department expected you to proceed?
I can't answer about the department's expectations, but there was certainly no secret from the people who participated in the plenary sessions that there would be times when we would be turning down an application because there were no records, and we'd be referring to the appeal panel. The way the referral to the appeal panel was made was a process that we developed ourselves, and which relied very much on the administrator's goodwill and sympathy with the applicant. So, I mean, Nick had his system. And somewhere I think I saw in the documentation the document he would provide to applicants to say how they should go about approaching the appeal panel, which is always helpful.
We can take that down, thank you, Shimik. There were a fair number of applications refused because of evidence of intravenous drug use. Your witness statement says that it was the view of the plenary planning meetings that intravenous drug use was a sufficient reason for rejecting an application, regardless of the credibility of a genuine route of transmission. The SF board had to accept this view as policy. Is this correct, that any evidence of intravenous drug use meant that an application was inevitably declined?
Yes.
Was the appeal panel in any different position, or did that policy apply equally to the appeal panel?
No, I don't think so. I think the appeal panel would take the same line.
And why was that?
Do you like your money, your tax money, given to somebody who developed Hep C through intravenous drug abuse?
Not quite what you say in your statement. Perhaps we'll look at it on screen. WITN 3070003, page 42. Paragraph 204. You're not, I think, simply saying there that if it was clear that the route of transmission was intravenous drug use, the application would be declined, which may be thought to be an entirely understandable position. You're saying there that intravenous drug use was a reason for rejecting the application regardless of the credibility of a genuine route of transmission. Yeah. So although there might be credible evidence of someone having received blood products or blood, any evidence of intravenous drug use, as it were, sounded the death knell for their application.
As far as we were concerned, the applicant could still go to the appeal panel.
But it doesn't sound as though they would get any further with the appeal panel.
Well, maybe that's not problem of the Skipton board. That's the way the system was set up, and I can't remember the correspondence now from Dr. Ramsey, which I saw in the document, the hearing, but it was because it's something that Dr. Ramsey was consulted by the appeal panel and answered the appeal panel. So I have no idea what it says there. I don't know what use the panel made of Dr. Ramsey's reply.
We can ask Professor Mildred, no doubt about that. If we go to SKIP 5030_045.
Just a moment. We're leaving this document now. Can we just keep it on the screen for a moment? Did I understand your earlier evidence to be that what the Skipton Fund were applying was the burden of proof as on a balance of probabilities as to whether someone had been infected by blood?
Yes.
And that was the sole test, the overriding test?
Yes, subject to something like this. Where
so,
if there was
the reason I ask is just what you've referred to, because the third sentence here suggests that the view was not one of the sufficiency of evidence, but a question of policy. Do I understand it correctly, or was the policy something which was a policy of, or an approach rather, to understanding how the balance of probabilities might be established?
I think the policy was adopted by the Skipton Fund because of the view expressed at the plenary planning meetings that we were told that evidence of IVDU was sufficient to rule out an application at our level.
And was this published to those who might be applicants to the scheme?
I cannot recall. I really can't recall that.
Thank
you. If we then go to SKIP 5030_045, this is guidance on assessing an application for the £20,000 payment. And if we pick things up at the bottom of the first page, section 3 for non-hemophiliacs, is there any evidence to suggest that the claimant's infection occurred because of exposure to NHS blood or blood products before September 1991? Yes, continue with this section. And then if we go over the page, is there evidence that a particular incident or course of treatment with any NHS blood product was responsible for the claimant's infection? Yes, continue with this section. And then the next question, is there evidence that a source of infection other than NHS blood or blood products could be responsible for the claimant's infection? Yes, reject application. Now, this would seem to suggest that if there was any evidence of another possible source of infection, the application was automatically rejected, rather than there being any attempt to establish on the balance of probabilities which was the probable cause or the most likely cause of the infection. Is that correct?
Yeah, I think it is, yes.
That's...
I can't remember when this guidance note was written or to whom it was addressed. But anyway, yes, I think you're right in your interpretation at that point.
That's not consistent with the balance of probabilities approach, is it?
It's completely consistent. I mean, if the balance of probabilities is clouded because there was, for example, into IBDA or an injection, transfusion, one can only say on the balance of probabilities we cannot decide.
I'm afraid that may be a misunderstanding, at least as I see it, of the balance of probabilities, because it's almost always the case that the balance of probabilities is something which is clouded. That's why it's a balance. There are probabilities on one side, probabilities on the other. What the approach you're describing, I think, is much more akin to the proof beyond reasonable doubt, as it used to be called, or satisfying someone so they're sure, as it is now. The standard which is adopted in criminal cases and not in civil litigation. But
right.
That's if you'll forgive me, that's an observation from a lawyer. You're free to comment if you wish, but otherwise you may leave it as just a reaction which I have unburdened myself of in the course of this exchange.
I certainly, I can't comment on your observations, Sir Brian. All I can say is that on this particular point, further exploration of this particular point would have to go back to the people for whom we were acting as agents in the administration of the scheme. We didn't invent these operating conditions.
Do you know who authored this document? Was it the department or Skipton, or do you not know?
I cannot remember. When I saw this document, I have no idea. Again, Nick Fish might know whether he ever consulted this document. I suspect it came from, it was produced from in the plenary planning meetings. If you were to find out that I wrote it, it wouldn't totally surprise me.
We can certainly pursue that further with Mr. Fish. Mr. Fish's predecessor, Keith Foster, the first administrator, defrauded the Skipton of some £400,000.
Yes.
I wanted to ask you about the Skipton's response to that by reference to a letter from Mr. Fish. Seamus, it's ABMU 5013. So this is a letter dated the 28th of November 2008 from Mr. Fish to Dr. Hay in his capacity as the then chair of UKHCDO. We can see in the long paragraph, it says, the alteration to the scheme came about when it was discovered that the previous scheme administrator, Mr. Keith Foster, fraudulently completed a number of application forms and misappropriated a large sum of money from the Skipton Fund. As a result, the Department of Health sent the NHS Counter-Fraud and Security Management Service to review the scheme's administrational procedures. And then it suggests that the measures suggested went beyond those finally settled upon by the Skipton Fund directors. But then says this, however, for all applications, it is now a requirement that we receive medical records to confirm that the applicant received treatment with NHS blood or blood products prior to September 1991. Previously, the doctor only had to state that they'd seen such records, and this is one of the loopholes that Mr. Foster exploited, and that they're currently Hep C positive or have undergone interferon-based treatment. So it would appear from this that Mr. Foster's fraud resulted in more onerous provisions for applicants and their clinicians in order to establish eligibility. Is that correct?
Yes.
Had there been any evidence of fraudulent applications by anyone other than Mr. Foster?
No.
How is what Mr. Fish says there a requirement to receive medical records consistent with what you referred to in your Archer evidence, and indeed what I think we discussed earlier, that there was a discretion that directors or the appeal panel could exercise in the absence of medical records?
If the application, if even after this change of practice, medical records were not available, an applicant could still make an application, and we could still exercise our judgment or decline it and say go to appeal. So it's all the change of procedure did was to make the preparation of applications more difficult for the applicant and his clinician, more reliable for us, but it didn't actually prevent people putting forward applications without any medical records at all.
If we can then look at SKIP 5030_017. These are the minutes of a meeting of the Board of Directors on the 1st of August 2007. If we go to the bottom of the second page, please. We can see under the heading Appeal Panel, Mr. Fish reporting that the panel had considered 97 cases, 50 resolved in the appellant's favour, 43 rejected, further information requested on 4. He also, top of the next page, reported that there are currently 6 cases yet to be heard. And then the next sentence, it was agreed that the fact that over half of the cases that went to appeal were upheld was not a poor reflection on SF's decision to decline certain applications, because the appeal panel are able to take many more factors into account when reaching their decision. Why was the appeal panel able to take more factors into account than the Skipton Fund itself?
Because they were able to and did ask people to supply as much supporting information as they wanted to, as they get hold of. The original application was based on the application form, and we only wanted information that was asked for on the form, or that went to confirm particular points on the form. We didn't want applications coming in that were 3 inches thick. The appeal panel were quite happy to deal with appeals that were even thicker than that.
Was that for practical reasons of not having sufficient time and resources to consider more detailed applications?
No, that was the process that was agreed in the plenary meetings, that to make it as simple as possible for the reporting clinicians to undertake the job, not to increase their burdens even further by saying, please provide this, that, or the other document, or it might be helpful to the applicant if such and such an information, such and such document was produced. It was simply the process was designed to be as straightforward as possible for the clinician helping his patient to fill in the application form.
Was there any attempt made to learn from the appeal panel's decision making, given that they were allowing a significant number of appeals?
Over time, certainly, the fund's success ratio vis-a-vis the appeal panel got better, but Nick, trying to remember, I have a feeling that we did actually ask from time to time for the appeal panel's view about the sort of problems they were being confronted with, and we never received any comment back saying, surely you should have known this one. By now you should have been able to work it out. So I think the balance between those applications we decided for ourselves, which was over 90%, well over 90%, and those who went to appeal was always about right. And the appeal panel eventually, I think I can't remember what the final score was in terms of success or failure of appeals, but I think in the end, the appeal panel upheld more than half of the fund's decisions.
Last question on Skipton, SKIP 5030_059. These are the minutes of a meeting on the 28th of March 2017 of the Board of Directors. Go to the second page, please, bottom half of the page. You can see in the penultimate paragraph on that page, the board expressed their surprise and disappointment that the NHS Business Services Authority had been announced as the successor to the company from the 1st of October 2017. Why was the board surprised and disappointed by the government's decision to reorganise the schemes as summarised there?
All the Alliance House operations had agreed that we were going to put in a joint bid to be the single scheme administrator. The Department of Health's decision to transfer the businesses to BSA was made without further consultation with us at all, so we were surprised. We were disappointed because we thought that we could actually do the job quite well. And certainly as far as the charities are concerned, with considerably more sympathy for and consideration for our registrants. This is not a point, obviously, that concerns Skipton. So I think surprise and disappointment is a fairly natural reaction.
Before I'll ask you some questions about the Caxton Fund, we can take that down, thank you. Can I just ask you briefly to explain to us what MFET was and what it did?
MFET, always known like that, was set up to administer the ex gratia annual payments that were made to recipients of Skipton 2, stage 2 payments. I think this is in response to Archer. The original plan, and for once I was in agreement with the Department of Health on this, which is rare, the original idea was that the payments, these are to MFET registrants, people therefore who are co-infected. Is that right? No, people with HIV. Yes, people who are co-infected because they received stage 2. Original idea that we had, that the Department of Health had, and I agreed with them, was that Skipton itself could manage these payments. It was set up to make tariff payments, not charitable payments, and these are not charitable. However, one senior member of the Department of Health team said no, Skipton should be preserved for Hep C use only. Another vehicle must be established to make these payments. Clearly, it couldn't be the charities because this is non-charitable work, so a new company had to be set up, or a new operation had to be set up. Reaching that decision took so long that a new operation couldn't be set up, so we dusted down MSPT2, changed its change its objectives, change its trustees as far as we could. And the first payment was made, the first of these ex-gratia payments were made by MSPT2. Subsequently, MFET, there was then time to set up MFET as a, I think as a non-discretionary trust. And MFET, that's all MFET did then. It simply paid out quarterly or monthly the equivalent of the annual ex-gratia payments to the registrants of MFT and ET who had received stage 2 payments from Skipton.
Caxton, then, you were a founding trustee of Caxton and its chair for the first approximately 2 years of its operation. If we look at CAXT 40108_017, please, Shomik. We can see these are described as the minutes of the meeting of the founding trustees and others, 4th of August 2011. And we can see from the list of those present that you, Mr. Evans, Roger Evans, and Mr. Gore, Charles Gore, were the 3 founding trustees. And then if we just go to page 3, if we just look briefly at page 2, just to put it in context. There's a section of the minutes headed The Genesis of the Caxton Foundation, and then there's a very brief summary of the position in relation to the Macfarlane Trust, the Eileen, the Skipton Fund, and then at top of the next page, MFET. And then we come on to the Caxton, where the minutes record you as having said this: Caxton was a further development aimed at bringing closure to the entire issue. A ministerial objective that there should be read across between the 3 charities would be difficult to achieve as each charity was an independent body. What was this ministerial objective that there should be read across? What did that mean, and what did they want you to do?
Read across could be otherwise spelled nonsense. In the event of what the ministers repeatedly, or each successive minister seemed to want, was that each the charities should do the same things, behave the same way. These are the 3 charities set up with different bodies, different community bodies, people who had different, between the charities, different conditions, different problems, and the charities were independent of each other and were required to be. So this is a typical politician's thing. Read across. If you'd asked if we had asked the ministers, what do you mean by read across? The answer would, I think, be even longer than anything I say about it. So we largely ignored it. I think we just carried on as charities independent of each other, doing what we believe to be appropriate for our beneficiary communities.
If we look at the next paragraph, it says the Department of Health had undertaken to provide funding for charitable disbursements of £2 million for the current year. It was expected that there would be additional funding from the DAs, that's devolved administrations, although it was not known how much or when the funds would be available. And then there's a reference to an opportunity for the minister to come and meet everyone. It sounds from that as though there may have been the same uncertainty over long-term funding as you've described in relation to the Macfarlane and Eileen trusts. Was that the case?
Yes, there was. I'm not even sure that we reached £2 million in that first year. I think in the end, the Department of Health funded what we said we needed to spend. The rate of applications to be registered with Caxton was less than we hoped and expected. On this particular occasion, we were able to do something about it because we knew who they were. But it took a long time. Certainly by the time I left at the end of 2012, I don't think we were fully up to where we had hoped to be or thought we would be by then. I don't think £2 million ever came in.
Is this right that the essential function of the Caxton Foundation was to provide or to consider the provision of discretionary payments to those who were eligible as Skipton Stage 1 recipients?
Correct.
If we go to the next paragraph, so it's the paragraph on the bottom of the page. Oh, in fact, it's already there, I think. You can see it records Mr. Evans saying that it had been determined by the 3 founding trustees not to appoint beneficiaries or user trustees to the Caxton board. There was a general consensus that while the views of the beneficiary constituencies should be sought in a manner that was open and transparent, it was premature to consider the appointment of user trustees. And then a view is expressed by Mr. Gore, and at the bottom of the page, Mr. Lister agreed but concluded it was important for trustees not to be seen as Ivory Tower residents. In the time that you were involved in Caxton, were there ever user trustees?
No.
Why was the Caxton Foundation not inclined to have user trustees?
I'm interested in that in a minute, but it was Roger Evans who stated that, because I would certainly regard myself as having been an obstacle for the appointment of user trustees on the basis of the mixed experience we had of them on the Farnham Trust. Bear in mind that when McFarlane Trust was first set up in 1988, we had 2 user trustees which went against the Charity Commission recommendation at that time. The Charity Commission subsequently changed their view, and the society then began appointing user trustees, some of whom were very good, some of whom were not so helpful. I felt that in the early days of this new charity, that we didn't really know very much about the people who would be coming to us to register, that it would be unhelpful to have user trustees at that stage. It's quite possible that had Caxton been able to last a bit longer before the Department of Health took it in, they might have had some user trustees. I don't know. By then, it's outside my purview.
It's recorded here that there was a general consensus that the views of beneficiary constituencies should be sought in a manner that was open and transparent. In the time that you were at Caxton, were there any efforts to seek the views of the beneficiary constituencies? And if so, what were they?
I don't recall any forum being established by which views might be sought, or any consultation going on. So no, I don't think any of that happened in those first 2 years.
And there was, I think, an issue about whether Skipton could or should pass details of those who'd received Stage 1 payments to the Caxton Fund, so that the Caxton Fund could make contact and essentially invite applications. Can you recall what the issue was?
I can't recall how that was managed within the GDPR requirements. No, I really can't remember.
Okay, well,
Nick Fish would probably know about that because he would have been the source of information about Skipton people.
Well, I can ask, no doubt, Mr. Fish or Mr. Evans, or indeed in due course Mr. Lister, about that. Do you know what efforts were made by the department at the outset to anticipate what the level of demand might be?
Well, they asked us. What else would they do? I mean, the department has no information about, no interest in this. So they would say, how much money are you going to need? How many people are you going to have to look after?
In the period that you were there, sort of the first 18 months, 2 years or so, what, if any, steps can you recall being taken to try and encourage applications to the Caxton Fund? Your statement notes that the number of applications was a long way short of the number of beneficiaries to Skipton.
No, I can't remember. I expect, I would imagine that, I mean, with thinking what we could have done, I would imagine that a letter would have been sent by Nick to all Skipton Stage 1 residents, pointing out that this operation existed for their potential benefit, and it's up to them to get in touch. I don't recall anything else. I can't think of anything else that would be appropriate at that stage.
Do you recall whether any consideration was given to introducing social events or educational seminars, as you had at Macfarlane Trust?
I don't recall that as being given much consideration again in those first 2 years.
Do you recall in those first 2 years any particular approach to reserves and a reserves policy?
I think in the first 2 years we agreed that the Charity Commission's requirement that charity should have a reserves policy was noted, and that Skipton had a policy. I don't think we produced a policy of so much money.
If we go to CAXT 40108_039, these are the minutes of a meeting on the 1st of September 2011. If we go to page 5, we'll see under the heading Draft Welfare Strategy Paper, reference to there being a debate about the policy direction the board might follow. Point 1, various classes of beneficiary, primary and secondary, should be treated equally in terms of identifying charitable need and providing relief regardless of how they fell into perceived poverty. The exception was those classified as carers. 2 refers to the establishment of a National Welfare Committee. 3, the Foundation recognises the need for direct financial relief to beneficiaries should be a policy objective together with individual social, economic and or educational empowerment. And then over the page, there's then reference to there being a need to identify a level of household income that the National Welfare Committee deem where a family might be in poverty. And that was, I think, subsequently determined to be £14,000. And then 5, that both income and expenditure should be taken into account. There'll be an annual census. 6, verification of income will be required in all cases. 7, both non-means tested benefits and means tested benefits should be income determinants. I think there may have been some variation to that. And then 9, in relation to carers, each application for support will be considered separately by the National Welfare Committee. Is that, there may have been some changes to the policy over the following years, but is that broadly the welfare strategy that the Caxton Foundation adopted, as far as you can recall?
As far as I can recall, yes. I mean, unless subsequent minutes record variations or additions to those 9 points, I think that was the policy that was accepted.
And then If we go to CAXT 40109_105. This is minutes of the meeting of the 1st of November 2012. If we go to the next page.
This must be my last one.
I think it probably was. Next page, please. Sorry, I don't have a reference noted of which page we need to look at. Ah, yes, so regular payment scheme. We can see the board received a paper considering the introduction of a regular payment scheme to Caxton beneficiaries, and then I don't need to go through the detail of it. I can ask others who continue to be involved, but it would appear from this that as at November 2012, there had not been a regular payment scheme yet set up. Are you able to assist with why it had taken that long to start considering a reg pay scheme?
No, I can't think of why that should have been. It doesn't strike me as being a very long period at all, considering we only started the previous year. We couldn't arrive with a reg pay scheme already on the shelf, as it were. It had to be considered by all the trustees, and one of the things that needed to be thought about was how many people were going to be eligible for it. Looking further down that, we see that the number of beneficiaries likely to be eligible for Skipton Stage 3 is 583, which is not very many. Only 40 people can return both part of the Simpsons forms. So we knew very little about possible demands that we've made on the fund at that stage. So a reg pay scheme I'm not surprised that a reg pay scheme didn't come into consideration until the later stages of 2012.
So I know at the time I've not got very much more on Caxton, so I'm going to suggest I finish those questions and we then take the break, which will give legal representatives of core participants the opportunity to suggest further questions.
Yes.
So just, I think, one more document and a handful of further questions on Caxton, Mr. Stevens. If we go to CAXT 40109_061, please. This is a note from you dated the 31st of March 2012 on the topic of board composition. And if we look at the second italicised paragraph, it says this: you might recall that there were a number of applicants for board seats who were not interviewed on the grounds that they were potential beneficiaries, an exclusion that was probably of doubtful legal validity. Several of these applicants came, not surprisingly, from the militant side. One is a press officer for tainted blood, another is the progenitor of the New Contaminated Blood campaign. While MFT has had some success with user trustees, they've not always been helpful, some finding it very difficult to leave the campaigning and representative aspects of their lives outside the board room. So were the recruitment process to be open and unrestricted, it might be sensible to have determined what particular skills, experience and attributes would be sought in order to be able to have a set of criteria that were defensible. Do we correctly understand this, Mr. Stevens, to demonstrate that for grounds which you accept here are probably of doubtful legal validity, the decision was taken not even to interview applicants for board seats simply because they were potential beneficiaries?
Yes.
Do you think that was appropriate?
Well, my paragraph here would suggest that probably wasn't.
And while I don't want to go back over the ground that we've already covered in relation to the Macfarlane Trust, but what's wrong with having on the board, for example, of an organisation such as the Caxton Foundation, someone who has campaigning and representative instincts and experience?
Because the Caxton was not a campaigning organisation, it was a grant-giving organisation on which decisions have to be made on grant applications on objective grounds and grounds of fairness. I don't think that campaigning is necessarily precursor to trustees would have the same, the relevant ability to be objective on behalf of other people, other applicants.
Not necessarily inconsistent with the ability to be objective and fair.
Not totally. No, not totally. So, so the further comments I make there by way of introducing a discussion would seem to be reasonable to open out the discussion and the interview process.
The last document, Mr. Stevens, is CAXT 5069_009. So this appears to be, it's a document headed Appeals Procedure in relation to Caxton. So we can see point 2, if the request is declined, the applicant can appeal against the decision. The appeal should contain additional information in support of the request. Then goes back to the National Welfare Committee. Then there can then be a further appeal to the full trustees board. Applicant will need to provide information on where grant should be agreed. That seems to suggest that there could only be an appeal against a decision, a first decision of the National Welfare Committee, if the applicant was able to produce additional information. Is that how it operated?
Yeah, I think so. In that there's no additional information, it would be difficult for the National Welfare Committee to change its mind.
But it would seem to preclude an applicant from being able to go to the Board of Trustees and say, well, I know the National Welfare Committee decided this, but look, they were wrong to do so, because I really...
The applicant could always write into the chairman.
And what would happen if... Was there any process as to what would happen in that event?
Then the chairman would do, in those first 2 years with me, would take it to we would start at step 5.
And did applicants know that they could do that?
I have no idea whether they even knew what this procedure was.
How many such cases did you have of people who wrote directly to you about this?
So how many?
How many cases did you have of people who wrote direct to you seeking an appeal?
Sir, I can't remember how many appeals we had. I can't remember how many letters came in to me.
But you did get some.
I'm not even sure if I did. No, I don't recall any.
Well, that's follows on from Council's questions about how people would know. It doesn't surprise me if they didn't know, and no reason why they should have known, that they may not have written to you about it.
No, but then I don't know how many appeals we had.
Yes.
I don't recall any appeals. So that process was, as far as I'm aware, available or made known to beneficiaries.
Last question for now on the Caxton Fund. When the Foundation, when it was being set up in 2011, was there any further consideration, as far as you can recall, given by the Department of Health to making provision for people infected with hepatitis B?
No, not I'm aware of. It's, after all, this eligibility to become a registrant of the Caxton Fund was dependent upon having received Skipton payment. Skipton was concerned only with hepatitis C. So hepatitis B was was not was irrelevant at that stage.
But nobody, as far as you can recall, raised it as something that should perhaps be included through widening the scope of Skipton.
Not that I can recall. No, I don't believe so.
Sir, I've got a couple of very general questions, but what I'm going to suggest is we break now for until perhaps 4. Representatives of core participants send to Ms. Scott and myself over the break any further questions they have arising out of Mr. Stevens' evidence, and then we can complete his evidence at 4.
Yes, well, we'll do that then. So until 4 o'clock, Mr. Stevens, then we have the last session.
Okay, so right. Thank you.